everybody. In this lecture, we will focus on companies and specifically on the procedures for the formation of a company, the notice of incorporation, memorandum of incorporation and the certificate of registration, as well as pre-incorporated contracts. In this lecture, we will investigate how a company is formed by focusing on the process of registration, the notice of incorporation, the memorandum of incorporation, and the certificate of registration. We will also briefly explain what a Section 21 pre-incorporation contract is by asking why such a pre-incorporation contract is important, by formulating a definition of this pre-incorporation contract, looking at the consequences if the company, which is then incorporated, ratifies such an agreement or does not want to continue with such an agreement, or if the company is not incorporated. Now, there are three main processes in the formation of a company. Firstly, there needs to be an application or a reservation of a name for the company. Then a notice of incorporation and a memorandum of incorporation needs to be filed with the Companies and Intellectual Property Commission. If that has been done in the prescribed format, then the Commission will issue a certificate of registration to say or confirm that all the requirements for the incorporation of the company have been complied with and that the company is now incorporated under the Companies Act as from the date and the time stated in the certificate. In the previous slide, we indicated that step 2 of the registration process requires the incorporators or founders to file a notice of incorporation with the CIPC. This is an example of such a notice of incorporation. A memorandum of incorporation also needs to be filed with the CIPC, and this is an example of such a memorandum of incorporation. Now, what are these examples and what is a memorandum of incorporation and a notice of incorporation? Well, a notice of incorporation have to be attached to the MOI or the Memorandum of Incorporation, and it must contain the name of the company, the incorporation date, the financial year end, the registered address of the main office, the number of directors, and the company name. And this notice of incorporation must also be accompanied by the certified copies of the IDs of the applicant, the founders, and the members of such a company. The memorandum of incorporation must be done in accordance with the Companies Act. Otherwise, such a company will be deemed void as if not registered. And the memorandum of incorporation is really the governing document of a company. It binds the shareholders to the company and the company to the shareholders and the directors. So, what must the memorandum of incorporation contain? Well, it will probably state the business activities of the company and then indicate the composition and authority of the board of directors. It will also tell you what the authority of the shareholders are and then stipulate how shareholder meetings will be held. It will also indicate who the incorporators of such a company are. And Section 13 of the Companies Act tells us that incorporators are one or more persons or an organ of state who may incorporate a profit company and an organ of state, a juristic person, or 3 or more persons acting in concert may incorporate a non-profit company. So what does this tell us? Who are incorporators? Very easy. Incorporators are merely the persons or the organ of state that incorporate a profit company, or 3 or more persons or an organ of state incorporating or finding or starting a non-profit company. The third step in registering a new company has to do with the commissioner of the CIPC. So Section 14 of the Companies Act tells us that as soon as practicable, after accepting the notice of incorporation, the Commission must assign to the company a unique registration number and enter the prescribed information concerning the company into the company's register, and then also endorse the notice of incorporation and the copy of the memorandum of incorporation that was filed. And then the Commission must issue and deliver a registration certificate in the prescribed manner and form. And why is this registration certificate important? Because it confirms that all the requirements for the incorporation of the company have been complied with and that the company is now incorporated under this act. So that the company, in other words, is now registered and incorporated and ready and able to do business. Because the registration and incorporation of a company takes a bit of time, this can sometimes present a problem to newly founded companies. When a company is not incorporated yet, any agreements will be deemed invalid and unenforceable. But while the company is being registered and incorporated, a company often needs to start doing business. A company often needs to secure business premises, enter into new contracts for new opportunities that may present themselves, secure supplier agreements, because all of this will show that the company is in business and will encourage the investors to have confidence in the new company and to invest in this new company. But the incorporators or the founders of such a company also need to protect themselves from any liability if something goes wrong. For example, if the company is not incorporated, or if the company is incorporated but does not want to agree with any of these agreements that were concluded before the incorporation of the company. And luckily, the Companies Act presents a solution to this problem by means of a Section 21 pre-incorporated contract. So what does Section 21 of the Companies Act say? It says that a person may enter into a written agreement in the name of, or purport to act in the name of, or on behalf of an entity that is contemplated to be incorporated in terms of the Act, but does not yet exist at the time. So let's just quickly, by looking at this definition, define what a pre-incorporated contract is. It is a written contract that is entered into in the name of or on behalf of a company that does not yet exist or is not yet incorporated, with the intention that this company will be incorporated and that upon incorporation, the third party will be bound by this contract. So it is a contract, a written contract, that is entered into before the company is officially registered and incorporated, because the company has the intention to be bound by this contract with the third person that it contracted with. So what are some of the formalities necessary for such a pre-incorporated contract to be valid? Firstly, it must be written. It must be on behalf or in the name of a company that still needs to be formed, that still needs to be incorporated. So this pre-incorporation contract is now being entered into by the person who acts on behalf of the company and the third party. All the formalities are met, it is written, it is on behalf of a company that is still in the process of being incorporated. And now 3 scenarios or possibilities arise. In the first scenario, the company is indeed incorporated and wants to continue with this pre-incorporation contract, and they decide to ratify this agreement. The second scenario is where the company is indeed incorporated but does not want to ratify the pre-incorporation contract and in fact wants to reject the agreement in its entirety or certain parts of the agreement. And then thirdly, there is the possibility that the company is not incorporated. So when the company is incorporated, there are 2 possibilities according to Section 21(4) of the Companies Act. Within 3 months, the board of the company may completely, partially, or conditionally ratify. So that means retrospectively accept the contract as if it was already a company properly incorporated upon agreement, or the board of this company that was indeed incorporated can reject the pre-incorporation contract. So if the company is incorporated and indeed decides to continue or to ratify, so retrospectively accept the pre-incorporation contract, that will mean that the agreement is as enforceable against the company as if the company had been a party to the agreement when it was made. So in other words, it was as if when the person on behalf of the company entered into the pre-incorporation contract, as if the company was already registered and properly incorporated. And that also means that the person who acted on behalf of this company is now discharged of any liabilities. And this is important, and we will discuss this in the next slide. So scenario 1, incorporated, wants to continue, therefore the newly incorporated company will ratify the contract and it will become enforceable, and the person who entered into this pre-incorporation contract will be discharged of any liabilities. But sometimes a company is indeed incorporated but does not want to continue with this pre-incorporation contract. So the company rejects part or the entire pre-incorporation contract. So within 3 months after the date of incorporation, the board may reject the agreement or part of it, and any action purported to have been done in its name or on its behalf. And what now? Because we sit with a contract with a person who acted on behalf of a company and with a third party who agreed to this pre-incorporation contract. In order to protect these third parties, Section 21 of the Companies Act stipulates that a person who does anything contemplated in subsection 1, this is now the person acting on behalf of the company, is jointly and severally liable with any other such person for liabilities created as provided for in the pre-incorporation contract. So what does this mean? This puts a personal liability on the individual who enters into a pre-incorporation contract on behalf of the company. So now this person who acted on behalf of the company who was still being registered and incorporated will now become personally liable if the company does not want to continue with this pre-incorporation contract. Then the possibility also exists that the company is not incorporated. And what will the effect of that then be on the pre-incorporation contract? Remember, that was concluded between a person who acted on behalf of a company who was being incorporated and a third party. Well, as was the scenario with a company being incorporated but rejecting the pre-incorporation contract, the third party will still be protected, and the person who entered on behalf of this company into this contract will be held personally liable for any liabilities created by this contract. So this is a very difficult situation and puts a lot of stress on the person who acted on behalf of a company who is not then incorporated. And therefore, the contract cannot be enforceable and valid against the company. There is, though, a solution in terms of the common law by means of the stipulatio alteri, or a contract not as an agent, or in other words on behalf of a company, but in terms of a principle for the benefit of a third party. And in such an instance, the contract, this pre-incorporation contract, will merely fall away, and there will be no liabilities incurred on the person who acted as a principal but not on behalf of a company still being incorporated. In this lecture, we investigated how a company is formed by focusing on the 3 steps: the registration of the name, the incorporation, the notice of incorporation, and the memorandum of incorporation that needs to be filed with the CIPC, and then the Commission issuing a certificate of registration, stipulating that all the formalities have been complied with and that the new company has now been incorporated under the Companies Act. We also looked at the pre-incorporation contract by focusing why these pre-incorporation contracts are important, defining such a pre-incorporation contract, and looking at the consequences if a company is incorporated and wants to continue with this pre-incorporation contract, when a company is incorporated but wants to reject the pre-incorporation contract, and if the company is not incorporated and the pre-incorporation contract thus becomes invalid and not enforceable.